Hello, and welcome to today's session. Learning Outcome, LO2. Understand the law relating to equality and discrimination. Today, we will explore a vital area of employment law, how UK law ensures fairness and equality in the workplace. The Equality Act 2010 serves as a cornerstone, consolidating previous anti-discrimination legislation and providing a comprehensive framework to protect individuals from unfair treatment. This session will examine how the Act operates in practice, highlighting its impact on promoting equality, preventing discrimination, and shaping employer and employee responsibilities. By the end of today's lesson, you will have a clear understanding of the legal mechanisms that uphold fairness in the workplace. Equality law aims to foster fairness and equal opportunities in employment. It prevents unfair treatment based on personal characteristics. Employers are held accountable for discriminatory practices. The law ensures decisions are merit-based, not biased. It consolidates over 100 pieces of legislation into a single coherent act. The Equality Act identifies 9 protected characteristics. These include age, disability, and gender reassignment. Others are marriage, race, religion, sex, sexual orientation, and pregnancy. Discrimination based on these is unlawful. Protection extends to all aspects of employment. Discrimination takes several forms under the Equality Act. Direct discrimination is less favorable treatment due to a characteristic. Indirect discrimination involves policies disadvantaging certain groups. Harassment creates a hostile environment. Victimization targets those who complain about discrimination. Employers must prevent workplace discrimination. This includes fair recruitment and promotion practices. They must provide equal access to training and pay. Anti-discrimination policies should be established. Employers may be liable for employees' discriminatory actions. Employees can raise grievances internally if they face discrimination. They may file claims with an employment tribunal within 3 months. Remedies include compensation for financial loss and emotional distress. Employers may need to change policies. Declarations can affirm rights were breached. The Equality Act allows positive action to address underrepresentation. This must not lead to reverse discrimination. Examples include mentoring women in senior roles. Encouraging disabled candidates to apply is another. Positive action helps achieve genuine equality without exclusion. Real cases illustrate discrimination law in action. Archibald v. Fife Council showed failure to adjust for disability. Attridge Law v. Coleman involved discrimination by association. James v. Eastleigh Borough Council highlighted direct sex discrimination. These cases underscore the importance of compliance. Non-compliance with equality law has severe consequences. Employers may face tribunal claims and financial penalties. Reputational damage and employee morale issues can arise. Attracting diverse talent becomes difficult. Public censure by regulatory bodies is possible. The Equality Act ensures equal pay for equal work. It eliminates gender-based pay discrimination. Employers must treat workers equally in pay and terms. Like work, equivalent work, and work of equal value must be equally remunerated. This applies to all contractual terms. Employees can claim equal pay if paid less than a comparator of the opposite sex. They must show work is like, equivalent, or of equal value. The comparator must be a real person in the same organization. Tribunals can order pay equalization and back pay. Successful claims bring significant compensation. Employers can defend pay differences with a material factor unrelated to sex. This includes seniority, performance, or market forces. Job evaluation schemes can justify pay differences. The factor must not be influenced by gender bias. Defenses must be proportionate and legitimate. The Equality Act supports pay transparency to address inequalities. Employers with 250 or more employees must publish gender pay gap reports. Case examples like Hayward v. Camel Laird highlight burden of proof on employers. Transparency encourages accountability and regular pay reviews. The Equality Act defines several types of disability discrimination. Direct discrimination occurs when treatment is less favorable due to disability. Indirect discrimination involves policies disadvantaging disabled people. Discrimination arising from disability relates to connected factors. Failure to make reasonable adjustments is also unlawful. Employers must make reasonable adjustments for disabled employees. This includes modifying duties, providing assistive technology, and adjusting work hours. Failure to do so is one of the most common forms of discrimination. Reasonableness depends on the employer's size and resources. Effective adjustments overcome disadvantages. Employers have a duty to identify and remove barriers for disabled employees. They must engage in open discussions and provide training. Legal cases like Archibald v. Fife Counsel highlight the importance of reasonable adjustments. Failure to comply can lead to tribunal claims and compensation. Proactive measures are essential. Breaches of discrimination legislation have serious legal consequences. Employees can bring claims to an employment tribunal. Compensation is unlimited and includes injury to feelings. Employers may face reputational damage and reduced morale. Compliance with the Equality Act is crucial. Employees have several routes to raise discrimination complaints. They can use internal grievance procedures or ACAS early conciliation. If unresolved, claims can be filed with an employment tribunal. Tribunals determine remedies and compensation. Early resolution is encouraged to avoid formal proceedings. Evaluating real-world scenarios helps identify potential discrimination breaches. Understanding equality law predicts legal outcomes and organizational impacts. Employers must balance business needs with employees' rights. Proactive measures prevent discrimination and ensure compliance. Analysis aids in creating fairer workplaces. Understanding discrimination law helps predict legal implications. Precedent cases illustrate common breaches and outcomes. Employers face serious consequences for non-compliance. Legal analysis aids in preventing similar issues. Compliance with the Equality Act is essential for organizational success. Employers should implement robust equality and diversity policies. Mandatory training for managers is crucial. Recruitment and redundancy processes must be fair and transparent. Regular reviews identify potential biases. Documentation supports decision-making and defends against claims. In conclusion, this video emphasizes the significance of taking proactive measures, demonstrating that adherence to equality law is crucial for achieving both fairness and success. Should you have any questions, you are welcome to reach me by text or phone on 07000 484 361 688. Thank you for your time, and I look forward to our next session.